And second, women who fear persecution solely because of reasons relating to kinship. Third, women who fear persecution resulting from conditions of severe discrimination on grounds of gender and who are at the risk of systematic violence at the hands of private citizens because the state is either unable or unwilling to protect them. Fourth is women who fear persecution as a result of transgressing religious, customary and social norms. When considering the persecution of women, it is vital to acknowledge sexual violence as a form of persecution and to include it in the instrument. However, formal recognition specifically of rape as a war crime has only recently been forthcoming, with both unofficial and official policy continuing to reflect the assumption that rape is an arbitrary act of harm, not a form of persecution. It is, however, often difficult to establish state responsibility for sexual crimes, even in the context of war situation, as the intimate nature of such crimes leads automatically to the assumption that these are personal crimes or random acts by individuals as opposed to state-sanctioned tactics. Today, however, international bodies are recognizing the true nature, brutality and the intent of such crimes. Acknowledging rape as an abuse of power and the means to achieving a political end is a step forward in reconceptualizing the persecution of women. Although it may not always be possible to draw a direct line of responsibility to the state, although in the case of Iraq it emerged subsequent to the Iraq invasion of Kuwait that there actually existed office in the civil service for the rape and torture of women. The widespread use of rape in war is premised and the implicit assumption that this is acceptable to and even sanctioned by the state. The tribunals for war crimes in Rwanda and Yugoslavia have both condemned rape as a crime against humanity, and the United Nations panel in 1994 ruled that rape related to ethnic cleansing constitutes a war crime and legally constitutes genocide. All these actions constitute state complicity if they deprive women of effective legal protection from abuse. The existence of legislation that seems to protect women should not be used as evidence of state protection in and of itself if it can be proven that abuses continue unchecked. For example, murder is a crime in countries in which honor killings, widow burnings and dowry murders are rife, yet such crimes are rarely prosecuted. Laws alone are insufficient to prevent mistreatment of women if there is no political will to enforce them. There are a number of reasons why governments might not enforce legislation that protects women. These include the fact that sexual discrimination is viewed as trivial, that abuse of women is seen as a cultural or private issue, that women's rights are not fully recognized as human rights, and that the abuses are seen as too pervasive to confront. Gender-related persecution is sometimes more subtle than other forms. It can take the form of restrictions on the way a woman behaves, or it can involve in forcing her to act in a certain way. There has been increasing concern among advocates and practitioners about the way in which the asylum claims of women who experience gendered social norms and mores are interpreted with international refugee law. In many contexts, women are subjected to discriminatory treatment and social norms which are enforced through law or through the imposition of cultural or religious norms which restrict their opportunities and rights. Gender social norms and discrimination are seen in but are not limited to legislated discrimination. For example, Pakistan's hudud laws are restrictions on women's movements or activities in Afghanistan, dress codes, employment or education restrictions, behavioral restrictions, for example, not going out in public without a male protector, marriage-related harm, including the consequences of remaining single, separated, divorce, and widowhood. In asylum applications, critical to the formulation of these claims is the fact that the applicant must establish that the government is the source of the persecutory measure, or that the government is unwilling or unable to protect her from persecution. When the treatment is through discriminatory statutes or laws, which may be gender neutral but are applied in a manner which target women and which are enforced by the government, state involvement is clear. The principle that states are responsible for changing domestic laws in order to bring them into conformity with international human rights law could simply be based on the notion that the state is bounded to do so under the international custom or treaties. For example, Articles 2F and 5A of the International Convention for the Elimination of All Forms of Discrimination Against Women require state parties to implement the appropriate measures to eliminate discrimination against women in customary practices. However, this rationale would not be applicable where the state has not ratified relevant treaties or has entered reservations that exclude the obligation to change religious or customary laws. For example, Egypt ratified the Women's Convention but entered a reservation on inter alia, Article 16, concerning equality between men and women in all matters relating to marriage and family relations. For instance, many states where honor killings occur have, however, not ratified any international human rights treaties under which they could be held responsible for their failure to protect the right to life of women, to respond effectively to violations of the right to life, or their failure to eliminate discrimination against women. For example, Pakistan, the state where at least 461 women were killed in 2002 in the provinces on Sindh and Punjab alone, is not a party to ICCPR, under which it could be held responsible for the failure to protect the right to life of women. Jordan, for instance, is a party to the ICCPR but has not recognized the Human Rights Committee's competence in accordance with the optional protocol convention. So on goes. Like many other forms of violence against women, honor killings become a human rights issue where states, due to unwillingness or inability, fail to protect the fundamental rights of individuals.